The federal government has made some very significant changes to industrial relations laws and looks to be continuing to shake up this space. One area in which this is happening is in the area of industrial action and strikes. For more, Andrew spoke earlier with Joydeep Kaur, Managing Principal of employment law firm People and Culture Strategies.
There's a lot at stake, and what we're seeing is probably some of the most significant changes to the workplace relations and industrial relations landscape in Australia, probably since the introduction of the work choices legislation in 2006. So we're talking about some pretty significant reforms, and we are seeing that transpire across a whole range of areas. So one area, for example, is the whole independent contractor versus employee in the context of the gig economy, where the government's talking about really unwinding a decision of the High Court, and a very significant suite of changes in the context of enterprise agreement making, bargaining, and in particular in relation to this concept of industrial action, and probably some of the most significant changes we've ever seen in Australia in the context of when employees can strike and what has to happen before that can take place.
So specifically, what are we talking about here? Because, of course, back in the 70s and 80s, Australia was riven with industrial action, with a lot of strike action, less so in the past couple of decades. But now, of course, business groups are sounding the alarm that these changes will mean that strikes are back on the agenda.
What's really interesting is you're absolutely right that there's been, in an objective sense, a fairly significant reduction in the amount of strike activity and industrial action that takes place. What a lot of people don't appreciate, though, is that the right to strike is actually permitted and has been permitted, regardless of whether it's a Conservative government or a Labor government in power, pretty much for the majority of Australia's history in the context of agreement making, so long as there is a genuine linkage between the proposed strike activity and the fact that a party is genuinely trying to make an agreement. So effectively the law recognises that it's fair game to engage in industrial action so long as that's in pursuit of a new enterprise agreement or an initial enterprise agreement between the parties. What is changing significantly is the procedural requirements that have to be discharged before that industrial action can take place. Now, in recent times, there's been recognition that before, and realistically, it's usually the unions that will drive industrial action campaigns. They will try to get the interest in that campaign from their members who work at a particular organisation. And the law says that the first step in that particular process, and this has been the case for a while, is that the Fair Work Commission must order the taking or the conducting of a protected action, in other words, for that industrial action to be protected and lawful, ballot order. And that ballot can be conducted by an approved agency, such as the Australian Electoral Commission and a couple of others. And so that's the first step. So you've got to apply to the Fair Work Commission. The Fair Work Commission has got to approve the making of that protected action ballot order. And they've got to set a date within which that ballot has to take place. Now, what's changed as of June of this year is that the federal government has said, look, that part stays as it is. However, in advance of the closing date of that ballot, there's got to be an attempt under the oversight of the Fair Work Commission, whereby the parties get together and have a conciliation conference where they narrow the issues that are in dispute. So the idea is that for the first time, the Fair Work Commission has a mandatory intervention point prior to that industrial action taking place. Now, you'd think about that and say, well, that makes sense, because if you can avoid industrial action with the assistance of an authority, that's probably not a bad thing. But what it does do is it introduces another layer of complexity. Certainly from the union's perspective, it's probably going to introduce some potential delays. But the thinking behind it actually makes a lot of sense. But how it's going to play out is going to be really interesting.
Yeah, so I guess the concept of a snap strike, that's not really possible, is it? And we've seen some recent examples of that with that industrial action on the Northwest Shelf involving both Woodside, which they managed to avoid, but Chevron workers walking off the job.
That's right. I mean, you can't stop those things from happening. If they do happen and the processes haven't been followed, then that is considered unprotected or illegal industrial action. And an employer has certain rights that are available to it to take action against those workers who may be engaging in that sort of wildcat industrial action, because it is not protected. By contrast, if the industrial action is taken under the protection of the legislation and all of the boxes have been ticked and the process has been followed, then employees are protected from any adverse consequences by their employer. So an employer can't issue warnings or terminate employees where they have taken protected industrial action because it's protected.
Okay, so it's not protected then. What, the employer is within its rights to actually dismiss an employee?
Yeah, well, it's theoretically, yes, because that industrial action represents a form of an employee refusing to do their work in accordance with their contractual obligations. So it would be treated in the same way, or could be treated in the same way by an employer as though an employee just refuses to show up for work one day or just point blank says they're not going to do their job. Now, whether an employer moves straight to termination in that situation or goes down the process potentially of issuing a final warning, what we see happen in practice is if an employer gets wind that some of this activity may be happening, they usually get on the front foot and say, look, this is letting you know that if you take industrial action in the manner that we understand some of you are thinking about, that's not lawful, it's illegal, and you need to be ready for what might be the consequences. We'd strongly encourage you to think twice about doing it.
Look, also on the agenda too, Joydeep, the business is critical of the government's efforts to close a labour hire loophole in the law. It's part of its omnibus bill. What does that amount to? It's changes where employers, the unions, they can apply to the Fair Work Commission to require labour hire workers to be paid at least the wages in that workplace agreement.
Yeah, that's right, because what's been happening for quite a long time now is that employers have avoided or tried to minimise the scope in certain circumstances of what they would be required to pay individuals if they were engaged as employees, because if they were engaged as employees, then the relevant enterprise agreement, assuming the employer has one, would apply. And so what a lot of organisations have chosen to do is that they've said, all right, well, we'll get this work done by a third-party labour hire company. We'll have a contractual arrangement with that labour hire company. That labour hire company is not bound by our enterprise agreement, so that labour hire company can pay what it likes to those particular people. We'll do the maths and we've worked out that we will save quite a bit of money through that particular arrangement. So that's the loophole that's going to be closed now, because effectively what is being sought is that if people are doing the same work for the benefit of the same business, why should they be paid differently if they are engaged by the employer directly as opposed to being engaged by a labour hire company? Once again, you can see the logic behind this. It's just going to play out in a very challenging way for employers in a tough economic environment.